In April 2023, Anheuser-Busch partnered with social media influencer Dylan Mulvaney to create an ad campaign. That ad campaign resulted in a boycott of Bud Light that cost the company over $21 billion in stock value over the following 2 months. In May 2023, Target said, "Hold my beer." Target's 2023 Pride collection resulted in an even bigger boycott that cost the company $10 billion in the first 10 days and over $19 billion in just 4 weeks. I am Dr. John Padfield, an engineer turned state representative turned business professor, and this is Business Reform, where we discuss issues at the intersection of business, technology, and society. In this video, we are going to examine multiple lawsuits that have been filed against Target Corporation, claiming the company prioritized promoting a political agenda over protecting shareholder value. Specifically, we will examine 3 lawsuits filed by investors against Target and its board of directors. But this video is about much more than just Target and their 2023 Pride campaign. It's about the bigger question of what is the proper balance between maximizing shareholder value and the board of directors acting on and promoting their personal values. The first lawsuit over Target's 2023 LGBT Pride campaign was filed by Brian Craig and America First Legal in August 2023. That case is simply known as Craig v. Target Corporation. Target's attorneys responded by filing a motion to dismiss, which tied the case up in court for over a year. Then, in December 2024, the U.S. District Court ruled in favor of the plaintiff and denied Target's motion to dismiss, which meant the case was now free to continue. This ruling also opened the proverbial floodgates, and the following month, in January 2025, the City of Riviera Beach Police Pension Fund filed a lawsuit against Target Corporation. And just a month later, in February 2025, the State Board of Administration of Florida filed another lawsuit against Target Corporation. The January and February 2025 lawsuits were covered by reputable news outlets, including Forbes. However, I prefer going directly to the source and quoting directly from the actual lawsuit rather than relying on a reporter's interpretation of what the lawsuit says. I have provided links to both the media coverage and the actual court documents in the description of this video. All 3 of these lawsuits are very similar in nature, and all 3 were filed in the United States District Court, Middle District of Florida, Fort Myers Division. What exactly are the plaintiffs claiming in these lawsuits? The court document is 163 pages long, but I've summarized the key points into the following 5 slides. Target Corporation and its board of directors betrayed both Target's core customer base of working families and its investors by making false and misleading statements about Target's environmental, social, and governance, ESG, and diversity, equity, and inclusion, DEI, mandates that led to its disastrous 2023 children and family-themed LGBT Pride campaign. The campaign provoked immense consumer backlash and boycotts that caused Target's sales to fall for the first time in 6 years and wiped out over $25 billion in Target's market capitalization, leading Target stock to experience its longest losing streak in 23 years. Target's CEO, Brian Cornell, and its board of directors did not oversee or disclose the obvious risk of Target's 2023 LGBT Pride campaign and the ESG/DEI initiatives which it advanced. They deceived Target's investors as to the true nature of the risk of their investments and caused them to unknowingly support Target's board and management in their misuse of investor funds to serve its divisive political and social goals and ultimately cost investors billions. Cornell violated Sections 10B and 14A of the Exchange Act rules, causing Target to issue misleading statements to investors. Target's 2021 and 2022 annual reports misleadingly omitted that Target was subject to the risk of consumer boycotts because of its ESG/DEI initiatives, like the 2023 LGBT Pride campaign. Target and its CEO and board chair, Brian C. Cornell, misleadingly downplayed the scope of consumer boycotts after they began. The lawsuit goes on for another 150 pages, going into detail about the 2023 LGBT Pride campaign, why so many people in Target's core customer base found it offensive, and how Target's decision to defend its original decision rather than listening to its customers caused stock prices to drop even further. The lawsuit ends with a section called Request for Relief, which states what the plaintiffs want the court to do. The two biggest issues being sought in this lawsuit is an order awarding plaintiffs the damages they sustained as a result of the disclosure violations listed in the lawsuit, and a declaration that Target's 2023 director election is void. I want to stress Target is not being sued for having conducted their 2023 LGBT Pride campaign. They are being sued for failing to disclose to investors what they were doing and the amount of risk involved. For anyone wondering how Target's backlash and boycott is any different than the 2012 Chick-fil-A backlash and boycott, I can answer that in one word: ownership. Chick-fil-A is a privately owned company, so they do not have to disclose anything to investors. But Target is a publicly traded company. That means the company is owned by investors and run by people who the investors elect to the board of directors. That means the owners are not involved in the day-to-day business decisions, such as what products to carry, whether to have an LGBT Pride collection, and if so, what products to include in it. The U.S. Securities and Exchange Commission requires the people elected to run publicly traded companies to regularly publish key information to the investors who own the company. If the investors are misled or not informed about potential risk, they could lose billions of dollars due to risky corporate management decisions, and that is exactly what Target is being accused of doing in these lawsuits. This is where things can get complicated. As a business professor, I am the lead faculty member for the supply chain management concentration on the campus where I teach. One of the topics I teach is supplier selection. When a manufacturing company is selecting a raw material or component supplier, there are a lot of things that need to be considered beyond the price and quality. Some considerations are purely business trade-offs, such as the lead time between placing an order and receiving material, or the minimum order quantity a supplier will accept when placing an order. Imagine you are the sourcing director for a large manufacturing company, and you have found two potential suppliers for some of the new parts you need to order. One supplier's price is 6% cheaper than the other, but the cheaper supplier has a terrible record on employee safety and has been repeatedly fined by the government for causing environmental damage. Would you maximize shareholder value and potentially your own bonus by selecting the cheaper supplier, or would you choose to do business with the more responsible and more expensive supplier? How much more, if any, would you be willing to spend to purchase parts from a factory powered by renewable energy? Would you buy products from a foreign company that relied on child labor as long as child labor was legal in that country? My point is, while publicly traded companies have a responsibility to be good stewards of investors' money, I believe there are situations where considerations other than profit must take priority. Exactly what those situations are is open for debate, and I would love to hear your thoughts about this in the comment section. Here is another example where I believe corporate profits were in direct conflict with corporate responsibility. In September 2011, 3 Chinese dissidents who were Falun Gong practitioners filed a lawsuit against Cisco in U.S. federal court under the Alien Tort Statute. They claimed Cisco, a San Jose-based technology conglomerate specializing in networking, cybersecurity, and IT infrastructure, assisted the Chinese government in identifying, detaining, and torturing members of their group. The plaintiffs claimed Cisco customized their products to help Chinese authority monitor and suppress Falun Gong practitioners. In 2014, a U.S. District Court dismissed the lawsuit, claiming the plaintiffs had not sufficiently demonstrated Cisco's actions directly led to the abuses. But in July 2023, the Ninth Circuit Court of Appeals overturned that District Court decision, so the lawsuit against Cisco could proceed. Just last month, Cisco filed a petition to the U.S. Supreme Court asking them to review the Ninth Circuit Court of Appeals ruling and I will make another video about this case as it continues to make its way through the judicial system. The point is, in the Cisco case, they made money by selling hardware and services to an authoritarian government who then used that technology to repress their citizens. If maximizing shareholder value was the only goal, then Cisco did the right thing. But if companies have some level of responsibility to society in general, and I certainly believe they do, then in my opinion, Cisco did the wrong thing by selling that technology and those services to the Chinese government. Regardless of the outcome of the lawsuits against Target, they are going to be very consequential. If the plaintiffs win, I believe it will tip the boardroom scales in the direction of maximizing shareholder value. If the defendants win, I believe it will tip the scales in the direction of corporate responsibility, which can very easily turn into corporate activism. I have a lot more thoughts about corporations and their obligations to investors, employees, and society in general. If you'd like to see more videos on these type of topics, please let me know. I look forward to reading your comments.